Good afternoon. Welcome to the Analyst. Today we'll be taking up 5 newspaper articles from the Hindu and the Indian Express and discussing them. The handout for the same will be available in the description of this video for your kind perusal. Please have a look at that. The first article that we'll be taking up is related to inequality, as a recent SBI report while examining the taxpayers' data has claimed that Gini coefficient in India has fallen from 0.47 in 2014-15 to 0.40 in 2022-23. The second article is related to basic structure doctrine, as the doctrine remains a permanent bulwark against tyranny and dictatorship in India. The third article is related to police abuse and human rights, as the Supreme Court observed that the 2022 incident of some Gujarat policemen publicly tying some people to a pole and flogging them amounts to atrocity. The fourth article is related to abortion, as the Delhi High Court did not allow a widow from terminating her pregnancy who is going through severe trauma and suicidal tendencies. The final article is related to Karpoori Thakur, as the government is going to award Karpoori Thakur with the Bharat Ratna, the highest civilian award in India. Now, the first article is related to inequality, as a recent report from SBI has examined the taxpayers' data and claimed that the Gini coefficient in India has fallen from 0.47 in 2014-2015 to 0.40 in 2022-23. Gini coefficient is a standard measure of inequality. That is, a Gini coefficient of 0 denotes perfect equality in any country, and a Gini coefficient of 1 denotes perfect inequality. So we will be looking at the topic inequality holistically, looking at the causes of inequality and the consequences of inequality, and a few suggestions too. This is important in the paper GS3 under the topic inclusive growth as well as Indian economy. Now, what is inequality? Inequality does not mean merely economic inequality. It can also mean social inequality as well. As per the United Nations, inequality means the state of not being equal, especially in status, rights and opportunities. And we look at the context of India, there are various kinds of inequalities. For example, let's look at some data that there is gender inequality. As observed by the Global Gender Gap report, India is placed at a very low position. That is, India is ranked at 127th place out of 146 countries around the world in terms of gender equality. Likewise, there is disparity in the wages. That is, women on an average, they are paid lesser wages as compared to men. As per the International Labour Organization, women in India are paid 34% less wages as compared to men for similar work. Likewise, there is disparity in agriculture also. That is, women constitute about 42% of the labor force in agriculture, but they own less than 2% of the land in India. That also is gender inequality, which is visible in the agriculture sector. Likewise, there is inequality in terms of caste also. That is, the average household incomes of the upper caste in India is more than 47% higher as compared to the national average income of the average household. Likewise, there is inequality in terms of religion. That is, the average incomes and the consumption expenditures of some religious minorities are more than other religious minorities too. For example, the incomes of Christians, Parsis, Jains, that is more than the incomes of Muslims and Buddhists. Likewise, in terms of ethnicity also there is inequality. As per some data, 45% of the ST population in India belongs to the lowest wealth bracket in India, whereas this figure is about 25% for the SCs, and for the other castes it is about 10% only. That is the number of people belonging to the lowest wealth bracket. Likewise, there is economic inequality. As per the report of Oxfam International, the World Inequality Report of 2023, 1% people in India, the top 1% people in India, they own 40% of the wealth, whereas the bottom 50% population owns only 3% of the wealth in India. that is huge inequality. Not only that, the number of billionaires in India, that has also been surging, especially since the pandemic times, especially since 2020, the number of billionaires has been increasing. This is a picture of inequality in India. Now, how do we measure the economic inequality? There are a few measures which are available. One is the Lorenz curve. Let's understand what is Lorenz curve. Lorenz curve is a curve between the cumulative incomes and the cumulative population. That is, if there is perfect equality in any country, then the 50% population, for example, will be having 50% income, and 20%, poorest 20% in any country will be having 20% of the income. Whereas when there is inequality, this curve shifts downwards. That is, if we can observe from here, 50% of the population will be having only 25% income. This is Lorenz curve. And if we compare it between the developed and the developing countries, usually in the developing countries there is higher inequality, and the Lorenz curve usually shifts downwards even further. That is, 90% population will be having 25% income only. Usually this is how inequality is measured in terms of the Lorenz curve. Gini coefficient is another measure. Gini coefficient is the ratio of the area which is covered under the Lorenz curve and the area of this triangle. Let's understand with the help of another graph. For example, this is the cumulative income and this is the cumulative population. Now, the Gini coefficient will be the area under the Lorenz curve, that is this area, divided by the area under this complete triangle. Therefore, when there is perfect equality in any country, the line will be the 45-degree line, and when there is perfect inequality in any country, then 100% population will be having only 0% income. Therefore, the Gini coefficient, which is the ratio between the area under the Lorenz curve and the area under this triangle, will become 0 if there is perfect equality, and the ratio will become 1, that is, this will become perfect inequality in case the 100% of population is having 0% of income, and the Gini coefficient will become 1. Now let's look at the graphs also. For example, if we look at the graphs of the share of the wealth held by top 1% in India, that has been increasing. This is for India, and it has been increasing ever since the 1961 onwards. In the last 2 decades particularly, the share of the wealth of the top 1% in India has increased by a lot. After this, the inequality is highest in China after India. Whereas in the other countries, it is not as much. And when we look at the income inequalities in India, there also it has been increasing, particularly in the past 2 decades. If you look at the incomes of the top 1%, it is at the highest level. Then comes the income of the top 10%, and for the bottom 50%, the incomes have actually been declining if we compare to the 1961 levels as the base year. Now, what are the causes behind this inequality? The causes can be multifold. One is inflation. Usually, inflation has a disproportionate impact upon the poor, because the poor, they are usually employed in the unorganized sector where the incomes are usually stagnant. For example, agriculture sector, for example, laborers. There the incomes are usually stagnant, and when the inflation increases, they slip into poverty because the prices of the essential goods also increase, whereas the incomes remain stagnant, and the inflation causes further inequality. Unemployment is another cause of inequality. That is, when there is poor participation of the labor force, then there will be further unemployment as well as inequality, as there will be disparity in the wages. Tax evasion also leads to inequality, further increase in inequality, because the tax rates in India, they are usually high, the individual tax rates, which leads to evasion, and this tax evasion leads to the creation of a parallel economy, and which further fuels the growth of the unorganized sector, leading to further inequality. There is regressive taxes also which promote inequality. Progressive taxes are those where the tax rates usually increase as the income slab increases. That is, the richer people who are earning more, they are paying more taxes. Whereas in the case of regressive taxes, for example, indirect taxes, there the tax rates are usually the same whether the goods or services they are bought by the rich or by the poor. That is, the regressive taxes also contribute to inequality. The agrarian strategy in India has also led to increase in inequality. For example, we brought in the Green Revolution. The benefits of Green Revolution, they chiefly went to the wealthy farmers. And the education and social indicators, if they remain poor, the developmental indicators remain poor, then the access to opportunities will not be as much, and it further contributes to inequality as it forms a vicious cycle. That is, poor education, poor access to health, etc., which leads to poor skill development, which further leads to poor employability and poor incomes, and further poor access to good quality education. Now, what are the consequences for inequality? One, it might lead to social conflicts. How? For example, there will be demands for reservations, like the demands by Patels, Marathas, etc. for reservation for government jobs. It may lead to more ethnic movements. That is, if there are feelings that a region is being discriminated against, there will be demands for greater autonomy. For example, the Nagas demanding for greater Nagalim area. It will lead to a sense of marginalization. For example, particularly among some religious communities, it will lead to a sense of marginalization that they are not getting equal access to the resources in India. And it will further contribute to poor developmental indices like infant mortality rate, maternal mortality rate, per capita income, etc., which will further contribute to inequality. Now, how can we deal with this inequality? There can be a few suggestions. For example, the government can promote employment generation. Now, Indian economy transitioned from the agriculture to the services sector directly, bypassing the manufacturing sector. Now, thereby some jobs were lost. Now, the government of India is promoting the manufacturing industry too. For example, the government is actively promoting the toy industry in India, likewise the textile industry, etc., which will contribute to more employment generation, which will reduce inequality. Taxation has to be a progressive taxation. We can minimize the regressive taxes, indirect taxes, and at the same time we can explore imposing wealth tax also, because as per the Oxfam inequality report, just a 2% tax on the billionaires in India will generate enough revenues for tackling malnutrition for the next 3 or 4 years. Likewise, we can promote the role of the civil society. For example, the promotion of SC/ST entrepreneurs under Stand Up India scheme, for example, the inclusion of women in the labor force, women empowerment also can be explored, and the promotion of skill development, the schemes like Pradhan Mantri Kaushal Vikas Yojana, etc., they will ultimately lead to better employability and rise in incomes. Affirmative actions can also be explored, because even the Constitution of India guarantees substantive equality through provisions contained under Articles 15 and 16, and not only procedural equality as per Article 14. Now, the next article is related to basic structure doctrine. The context behind it is that it remains a permanent bulwark against tyranny and dictatorship. This is important in the paper GS2 under the topic basic structure. Now, what is basic structure? It is a judicially innovated doctrine. As per this, there are certain founding pillars, certain building blocks of the Constitution upon which the Constitution rests. Now, if these are shaken, the very essence of the Constitution may get lost. The former CGI Chandrachud even calls it the North Star, which helps in guiding the interpretation of the Constitution. It can be termed like a judicial measure against the parliament or the executive overstepping their mandate. Now, its evolution can be traced to the debate between socialism versus liberalism. Let's understand how. For example, the government tried to implement the land reform laws. Naturally, for this, the government had to acquire the land and some compensation was to be given. Now, because the compensation amount which was given was not adequate, therefore those laws were challenged. Now, because those laws were challenged, subsequently the government came up with the first Constitutional Amendment Act, which inserted the 9th schedule under the constitution. According to this, the laws which are enacted by the government and they are inserted in the 9th schedule, they are beyond the scope of judicial review, and hence government tried to implement the philosophy of socialism. Now, this was discussed in the case Shankari Prasad versus Union of India, whereby the first constitutional amendment which was undertaken by the government inserting the 9th schedule to the constitution, its constitutionality was discussed, and the court upheld the constitutionality of the first Constitutional Amendment Act, and it observed that the parliament has unlimited, untrammeled, unbridled amending powers. It can amend the constitution. Now, this remained the state of affairs until Sajjan Singh versus State of Rajasthan case in 1965. In this case, there were two dissenting opinions, one by Justice Hidayatullah, whereby Justice Hidayatullah observed that if there is unlimited amending power to the constitution, to the parliament, then it might even lead to a substitution of the constitution. It may not be an amendment, it will be an altogether abrogation, substitution to the constitution. Therefore, there has to be some limitations upon this. Further, in IC Golaknath and others versus State of Punjab case, the court observed that the fundamental rights, they are sacrosanct in nature, they cannot be amended. Therefore, the amending power of the parliament under Article 368 of the Constitution, that is subject to Part 3 of the Constitution, that is, the fundamental rights, they cannot be amended. Part 3 of the Constitution cannot be amended. Now, the parliament responded through the 24th Amendment Act in 1971. In this, the parliament said that the word law, which is contained under Article 13, that does not apply to amendments. Article 13 essentially ensures that if the government enacts any legislation and if it is infringing upon the fundamental rights which are guaranteed under Part 3 of the Constitution, they will be termed as unconstitutional and void by the judiciary. The parliament through the 24th Amendment said that the word law does not include amendments to the constitution. Therefore, the parliament can amend the Part 3 of the constitution also. Now, the judiciary finally came up with the basic structure doctrine through the Keshavananda Bharati versus State of Kerala case in 1973, whereby by a wafer-thin majority of 7:6, it was a 13-judge bench, the court observed that the amending powers of the parliament, they have to be limited. That is, there has to be defined a basic structure of the constitution which cannot be violated. Thereby, Justice H.R. Khanna observed, he applied the Conrad doctrine in the case of India also. Professor Conrad is a German jurist who observed that any amending authority which is deriving any statutory authority cannot exceed its mandate and change the very authority, very constitution from which it is deriving its own authority. Therefore, applying that Conrad doctrine, Justice H.R. Khanna observed that the amending power of the constitution has to be subject to a basic structure, and this basic structure cannot be violated. Now, there was no exhaustive list of the basic structure, the features which constitute the basic structure of the constitution, which was given in the judgment, but subsequently more features were added to the part of basic structure, that is, they constitute the basic structure. For example, secularism, like federalism, rule of law, judicial review, judicial independence, etc., that they form the part of the basic structure. In 42nd Amendment Act, the government again tried to increase the amending power of the parliament, saying that the government can take away any fundamental rights for the implementation of any directive principles. The DPSP is contained under Part 4 of the Constitution, not only to implement Article 39B and C, but to implement any directive principles. Therefore, this was finally settled in the Minerva Mills case by the court. This case is known as the bedrock of balance case, and the court observed that the amending powers, they have to be subject to the basic structure doctrine. The basic structure doctrine enunciated through the Keshavananda Bharati case was upheld here. And in Vaman Rao and others versus Union of India case, the court observed that any amendments done to the constitution by the parliament after the Keshavananda Bharati judgment will be tested on the touchstone of the basic structure doctrine which was enunciated through the Keshavananda Bharati case. Now, what is the significance of basic structure doctrine? One, it ensures the supremacy of the constitution. That is, a temporary majority of the parliament, because the parliament is usually constituted of the members who are chosen by the people through elections, that cannot take away the basic provisions, the basic structure of the constitution, and it ensures the supremacy of the constitution, thus preserving the ideals of the founding fathers. This essentially prevents totalitarianism. It ensures democracy, at least an uncertain democracy over a maybe certain tyranny if the very constitution can be abrogated. And it has been applied responsibly by the judiciary. For example, out of about 60 amendments which have been taken up by the government after the Keshavananda Bharati case, only 7 have been struck down by the judiciary on the grounds of violation of basic structure. Out of those 7 also, only 1 was struck down completely. That is the NJAC case, the National Judicial Appointments Commission, because it was affecting the very judicial independence, which forms the very basic feature, very essence of rule of law also in India. In the remaining 6 constitutional amendment acts also, which were substantially struck down by the judiciary, there also they were affecting the very judicial independence or judicial review. It was curtailing the role of judiciary. For example, in the case of Indira Gandhi versus Raj Narayan case, the court had observed that even for the election to the topmost post, constitutional post or other authorities in India, they cannot be beyond the purview of judicial review. In Article 368, there is no express limitation which is provided on the amending power of the parliament, on the power of the parliament to amend the constitution. But that does not mean that there are no limitations. Through the doctrine of implied limitations, through the doctrine of limitation of powers, there has to be some limitations which have to be read into it. But there are certain criticisms also of the basic structure doctrine. One, there is no constitutional basis. There are no provisions in the constitution which are defining the basic structure, the features which constitute the basic structure of the constitution. Also, there can be an element of subjectivity. That is, there is no exhaustive list of the features which constitute the basic feature. Therefore, it can vary from the opinions of judges, from one judge to another judge. It might amount to judicial overreach also at times when the judiciary is overstepping its mandate and striking down a constitutional amendment act. But overall, it has stood the test of the time, the basic structure doctrine, and therefore it stands as a bulwark against tyranny in India. Now, the next article is related to police abuse and human rights. The context behind it is that recently Supreme Court observed that a 2022 incident whereby 4 Gujarat police officers had publicly flogged some men for allegedly disturbing a Garba event in Kheda district in Gujarat, that amounted to atrocity by the police. So we will be discussing a few case laws and a few steps by the judiciary whereby it tried to uphold the human rights, protect the rights in India, and limit the police abuse of powers by the police. This is important in GS2 in governance. It can be asked in interview also. Let's look at some case laws regarding the police abuse. One, regarding the registration of FIR. That is one area where the police abuses its power sometimes. In this matter, the court observed in Lalita Kumari versus Government of UP case that when an information regarding a cognizable offence is received by a police officer, registration of an FIR is mandatory under section 154 of the CRPC. Now the new codes have come into picture, if the information relates to a cognizable offence. And in case the police officer decides that a preliminary inquiry should be conducted before the registration of an FIR, in that case, the preliminary inquiry should not be to determine the veracity of the information. It should only be to determine whether the information is related to a cognizable offence or not. Hence, the rights of the victim have to be ensured, because the registration of FIR will ensure the access to justice. Otherwise, that may also be missing. Then in Sakiri Vasu versus State of Uttar Pradesh case, the court said that if the police does not register an FIR, then the magistrate has the powers under section 156 subclause 3 of the CRPC, the Criminal Procedure Code, to direct the registration of an FIR. Here the court read the doctrine of implied powers. It means that if an authority is vested with the power to perform a function, then all the incidental ancillary powers required to perform that function properly are also vested in that authority. Therefore, the magistrate has implied powers to direct the registration of FIR under section 156 subclause 3 of the CRPC as well. In case of arrest also, police abuses powers. For example, for this the court observed in Joginder Kumar versus State of Uttar Pradesh case that the rights have to be balanced. That is, the rights of the accused and the rights of the society, they have to be balanced. The accused has the right to freedom. His freedom should not be taken away unnecessarily, but if there is no arrest, then there will be more crime in the society. Therefore, the rights of the society, which is a collection of the individuals only, that also has to be protected. Therefore, there should be a balance. And as per the National Police Commission third report, the court observed that the power of arrest, that is the chief cause of corruption in police, and 60% of arrests in India, they are unjustified, they are unreasonable actually. And therefore the Article 21, which guarantees the right to life and liberty, it also gives the right to self-esteem and reputation, which will be at stake. Therefore, merely on the basis of an allegation or suspicion, there should be no arrests. In D.K. Basu versus State of West Bengal case, it's a landmark case regarding custodial violence as well as arrest, etc. The court gave certain guidelines. It said that some directives should be adhered to at the time of the arrest, that when a police officer is going to arrest a person, he should show his ID, an identification card, in a very transparent manner, and there should be a memo of arrest which should be prepared at the time of the arrest. And when some person is arrested, information must be given to a friend, to a relative of the person who is arrested, and a diary entry is mandatory. That is, the person who is arrested, he is taken usually to a police station, and there is a diary, and the diary should have an entry of that arrest, and a medical examination should be conducted of the person who is arrested every 48 hours, and he should have access to the legal services. He should be allowed to consult his lawyer, including during interrogation, though not at all times during interrogation. And as per Article 20 subclause 3, it is under the Indian Constitution, it is giving the right against self-incrimination, that no person shall be compelled to be a witness against himself or herself, thereby any statement given to the police during custody, if it is extracted under force, under undue coercion, etc., that will not be amounting to an evidence against the accused. Under the case Khatri versus State of Bihar, the court observed that free legal services should be provided to the people who can't afford legal services. That is, free legal services, they are a part of the just, fair and reasonable procedure. The right to free trial is also a part of the fundamental rights under Article 21. For the cases of bail, because police abuses its powers in the cases of bail too, the court observed in the case Sanjay Chandra versus CBI, the court discussed two principles of criminal jurisprudence in India. That is, one, there should be a presumption of innocence. Unless proven guilty, the accused has to be presumed innocent and there cannot be any trials by the police, and bail should usually be the rule. To protect the human rights, bail should be the rule and jail should be the exception, and this has been quoted again and again by the court, for example in Arnab Goswami case as well. And the court said that there should be a few factors which should be considered while granting bail or rejecting bail. That is there a flight risk? The person who is accused, is he going to abscond if we let him go on bail? Is he having the capability to influence the witnesses? Will he be able to influence the witness and destroy evidence or tamper with evidence? Or is it likely that the gravity of offense is such that it will have negative repercussions in the long term? In Husainara Khatun versus State of Bihar case, the court said that the bail amounts should also be reasonable. Usually the courts have a property oriented approach. That is, before they let go of any accused, they usually ask for a lot of money as a surety that he will not abscond. Now the court observed that the financial solvency of the accused should also be taken into consideration. How much assets, how much money does he have? If he is not able to furnish the bail amount, there is no point. Regarding investigation, the court, while protecting the rights in Selvi and others versus State of Karnataka, observed that because Article 20 subclause 3 provides the right against self-incrimination, therefore there cannot be any involuntary admission of the narco test, polygraph test, etc. because they will also amount to extracting information without consent. To protect the fundamental rights also, there are a few case laws. In Rudul Shah versus State of Bihar, the court observed that the writs which are usually issued under Article 32, the higher judiciary issues writs under Article 32 for the enforcement, for the protection of fundamental rights. They can include monetary compensation too. If a victim has been wronged, then the court can award monetary compensation also through the writ under Article 32. In Nilabati Behra versus State of Odisha case, the court observed that because the government has a liability to compensate, the public law liability to compensate, it cannot claim sovereign immunity. Sovereign immunity means that the state usually seeks immunity from being sued by its own citizens. Now these were a few case laws regarding the protection of human rights by the court to protect from the police abuse as well. The next article is related to abortion. The context behind it is that the Delhi High Court recently did not allow a widow to terminate her pregnancy. Initially, the Delhi High Court had allowed, but later on it withdrew its own order, and the victim is going through immense trauma and suicidal tendencies also. This is important in the paper GS2. We will be discussing abortion, the Medical Termination of Pregnancy Act in India. Earlier there was the Medical Termination of Pregnancy Act 1971. There were some amendments which were taken up in 2021. Let's look at the amendments first before coming on to the arguments. As per the Medical Termination of Pregnancy Act 1971, up to 20 weeks the abortion can be done by a married woman only for the abortion of up to 20 weeks of fetus. Whereas the amendment of 2021 allows voluntary termination of pregnancy by unmarried women also. Up to 12 weeks, usually the advice of one registered medical practitioner was required under the earlier act. Now also it is the same. Up to 20 weeks, earlier there was the requirement of the advice of two registered medical practitioners for the termination of pregnancy. Now only one RMP's advice will be sufficient. To more than 20 weeks, there was no termination of pregnancy which was allowed under the earlier act, but now up to 24 weeks, if two doctors recommend for the termination of pregnancy, for some categories of women it can be allowed. They include, for example, the rape victims or the women facing mental issues, etc. For more than 24 weeks, earlier it was not allowed, but now it has been allowed if it is recommended by the state level medical board in case of substantial fetal abnormality. And in case of breach of confidentiality, earlier the fine was 1000 rupees, now it is fine or even imprisonment of up to 1 year also. And the termination of pregnancy can be any time if it is required in the opinion of one RMP for saving the life of the pregnant woman. Now let's look at the arguments in favor of the abortion law and against it also. There are two schools of thought. One school of thought says that there should be a right to freedom of choice, the freedom of choice of the woman, and the other school says that should be the right to life of the unborn fetus as well. Now let's look at the arguments in favor first. That women should be allowed to abort because they have the bodily autonomy, that the right to have that reproductive choice should be given to the women. Second, the freedom of choice and life course will be impacted if they are not allowed to abort, that is the future course of life, the career, etc. they will be impacted, therefore they should be allowed to have that freedom. It will allow avoiding the unsafe abortions, because if the abortion is not legalized altogether, this will go underground and there will be unsafe abortions. If the fetus has abnormalities, usually abortion should be allowed, and the evolving social norms also require the laws also to evolve. For example, there are rising number of cases of live-in relationships, premarital sex, etc. Therefore, voluntary termination of pregnancy for unmarried women has also been allowed. And there can be marital rape victims also. For them too, there should be abortion which should be allowed. There are certain arguments against allowing abortion too. One, it may cause fetal pain also, that is, the fetus also has a right to life, and it can have a devastating psychological impact too. For example, as per some empirical studies, women who undergo abortion, they experience depression also. And for the sake of adoption, the abortion should not be allowed. That is, the number of babies who are available for adoption in future might come down. And the parents, the mother should behave responsibly, and her own morality should also be taken into account. These are some of the arguments against allowing abortion. Now, what can be the way forward? One, we can see it like a human right, that these human rights should be protected, and the unsafe abortions have to be prevented, because the WHO classifies abortions into safe, less safe and unsafe categories, and we can prevent the unsafe abortions. And at the same time, there should not be any gender based violence, because it is termed, the allowing of abortion is also termed as gender based violence as per some schools. Now, the next article is related to Karpoori Thakur. The context behind it is that Bharat Ratna is going to be awarded to the socialist icon Karpoori Thakur posthumously. This is important in the prelims in the topic current affairs. Now, Karpoori Thakur was the former CM of Bihar. He was known as the Jan Nayak. He participated in the Quit India movement too. He was an active votary of Hindi language. For example, as an education minister of Bihar, he took away the provision that English should be a compulsory language at the metric level examination, and he imposed a total prohibition of alcohol in Bihar too, and he is termed as the champion of cause of Dalits, as he introduced the reservation for backward classes in government jobs in Bihar. Let's look at the Bharat Ratna also. Bharat Ratna is the highest civilian award in India, and the people who are awarded the Bharat Ratna, they are 7th in the order of precedence in India. Usually it is given to anyone who is having an exceptional service or performance of the highest order in any field of human endeavor. The first recipients of Bharat Ratna include C. Rajagopalachari, S. Radhakrishnan and C.V. Raman, and usually there is no monetary grant which is given to the holders of Bharat Ratna. Only a certificate which is signed by the president and a medal is given to the recipients of the highest civilian award in India. Thank you.